Sir, just give me a minute. It is starting. Like the link
Okay,
will
okay.
be starting soon. Yes, sir. Now we are live on YouTube. I, on behalf of Legal Expatiate, welcome you all to the 23rd webinar of Legal Expatiate on various law subjects, for which we are honored to have with us S.S. Upadhyay, sir, who is a former district and sessions judge and also a legal advisor to governors of Uttar Pradesh, India. Shri Sham Shankar Upadhyay has been a district and sessions judge in Uttar Pradesh. He has served as judge in district judiciary in different capacities in several districts of Uttar Pradesh and has also served as additional director of training at the Institute of Judicial Training and Research, Uttar Pradesh, Lucknow. He has trained judges, magistrates, police officers, and jail authorities, public prosecutors, and others in legal and judicial matters. His services for providing training in legal matters to the administrative officers of various levels are also solicited at the Uttar Pradesh Academy of Administration and Management, Lucknow. He has delivered more than 7,000 lectures on several important law subjects at judicial training academies of various states. At the Lok Nyayalaya, Jayaprakash Narayan Institute of Foreign Sciences and Research, Rohini, New Delhi, Dr. Ram Manohar Lohia National Law University, Lucknow, and also at several other universities of India. He has prepared huge valuable reading materials for judges, magistrates, public prosecutors, jail authorities, police officers on various law subjects, and the same have been published in many journals, brochures, magazines, and books, etc. These articles are also available on his website named lawhelpline.com. He has authored 5 books titled The Governor's Guide, Power and Functions of Governors under the Constitution of India, University Law in India, Law of Disciplinary Proceedings in India, Life and Legacy, and Dictionary of Urdu, Arabic, and Persian words as used in courts. The said books has also been published by the world famed law publishers LexisNexis and Thomson Reuters and have been appreciated by the Honorable President of India, judges of Supreme Court of India and High Courts, and the other constitutional dignitaries. The said books are available on Amazon and Flipkart for online purchase. Many articles written by him on different subjects of social, literary, religious, and spiritual importance have also been published in several magazines of different organizations in different states of our country. He has delivered lectures on various law subjects to the teachers of various universities of India under the UGC-sponsored refresher programs from 2011 to 2018. Shri Upadhyay has served at Raj Bhavan, Lucknow as legal advisor to 3 honorable governors of Uttar Pradesh. Several articles written by him on various law subjects are posted here for use of judges, lawyers, law teachers, law students, law researchers, and all those who need guidance on any law subjects. These articles are, again, I would like to repeat, these articles are available on his website, that is lawhelpline.com. We are honored to have such an eminent persona amongst us today who will be delivering lecture on art of contesting appeals. I would request the participants to put their queries in YouTube chat box, if any. Over to you, sir.
Good evening, participants. The subject for our discussion today has already been brought to your knowledge by the organizer of this event. We will be discussing today what is the role, what should be the skill, and what should be the art of an advocate arguing an appeal preferred against judgment of conviction and sentence. You know, the Code of Criminal Procedure provides for different types of appeals. Sections 372 to 394 provide for the power, procedure, and function of the appellate courts. An appeal can be filed to a forum, to an appellate court, only when law gives a right to the appellant to file such appeal. It's a statutory right. There are set of procedural prescriptions contained in CRPC and also in various leading judgments of the Supreme Court of India, which guide the appellate courts, the appellants, and of course, the lawyers who are the architects of the appeals. So since you already know the basics of the subject, therefore, I need not to go into all minute nuances and details of the subject. I will just take you to the practical aspects of this subject. As an advocate, when you draft an appeal against conviction and file it before the appellate court, then your role starts. Rather say, your main role is to convince the appellate court to earn an acquittal for the convicted appellant. What should be your role? What skill, what art you must possess to perform your duty excellently before the appellate court? I will be taking you through all this one by one. But before starting, I draw your attention. There is a website of mine on Google, lawhelpline.in. It was perhaps wrongly introduced to you as lawhelpline.com. It is not .com, it is .in, I-N. The name of the website is lawhelpline.in. For the last many years, it is there on Google. More than 7,000 pages are there on this website on different law subjects, including this one, which I am going to discuss today with you. I have today prepared certain points for your use, for your perusal, regarding your role in arguing the criminal appeals. I will take you through these points one by one. And again, reminding you that this subject of discussion today is also available at item number 39 under the caption Criminal Laws on my said website, lawhelpline.in. So let us come and discuss your role as advocate in arguing the criminal appeals. Point number one, first, appellate court, power and functions of appellate courts. You know, section 386 of the CRPC provides for the powers of the appellate court. When a judgment of conviction and sentence is passed by the trial court, the forum of appeal is from magistrate's court to the sessions court. And if the trial court is the sessions court or the court of additional session judge, then high court is the forum. And if in its extraordinary jurisdiction, high court itself has exercised its power of trial of a criminal case, then the first appeal lies from the judgment of the high court to the Supreme Court. Section 374 of the CRPC provides like that. Here is an appeal wherein conviction has been recorded by the trial court, whether it is magisterial court, sessions court, or say the high court. It can be better called the trial court. First appeal lies from magistrate's conviction to session judge, from sessions to high court, and from high court to Supreme Court. So this 374 CRPC covers all the first appeals irrespective of the forum which had passed the judgment. You as an advocate, while arguing the criminal appeal, must be familiar with the powers, functions, and procedures of the first appellate court. You know, as provided under section 386 of the CRPC, first appellate court is laced with quite vast powers. It has double powers, one of the appellate court and also of the trial court. All those powers which were vested in the trial court, they are exercisable by the first appellate court while hearing and deciding the first appeal. If you go through the bare legislative provisions of 386 CRPC, it will make you amply clear the extent of powers and functions of the first appellate court. So before arguing a criminal appeal, as an advocate engaged by appellant, your duty is to make you familiar with the power, procedure, and function of the first appellate court. The sources, the prime source, the legislative sources, section 386 CRPC. Over the period, in Supreme Court judgments, the scope of section 386 CRPC has been clarified time and again. The first duty as lawyer, which is cast on you, is to be familiar with the power, procedure, and function of the first appellate court. Then you know the duty of the appellate court is to reappreciate the entire evidence that was led before the trial court. An appellate court cannot keep itself confined to mere agreeing or disagreeing with the findings recorded by the trial court in its judgment. The duty cast by statute on first appellate court under 386 is to appreciate afresh the entire evidence available on record. When I speak among judges in their training sessions, then I suggest them you don't go through the findings recorded by the trial court in its judgment. Your duty is to read the entire evidence on the record of the trial court on your own. You record your own finding. You record your own conclusion of acquittal or conviction. And when you prepare your draft judgment finally, only then you see what was the finding, what was the reasoning, what was the conclusion reached by the trial court. Otherwise, once an appellate judge goes through the findings recorded by the trial court in its judgment, so then prima facie, he makes up his mind, taking many clues, many guidelines from the manner of appreciation of evidence made by the trial judge in his judgment. It's not the role of the appellate court. Appellate court is laced with double powers, those of the trial court as well as of the appellate court, as I earlier pointed it out to you. Then appellate court's duty is to appreciate the evidence afresh. What is your duty as an arguing counsel? You must point out during the course of your submissions all those material evidences, oral or documentary, to the appellate judge which are relevant for purposes of the judgment. So once you are familiar with the role of the first appellate court, you will be able to put forth your arguments in a better manner. Next point which I wish to press to you is before starting to argue your appeal, you should be well prepared. You must have in your possession the FIR, where from the case had started, the application that was presented to the SHO for registration of FIR, if there was an application at all, then how the case was developed during the course of investigation by the investigating agency, the statements of the witnesses recorded under 161, 164 of the CRPC, all the evidence that was collected by the investigating officer during investigation, what is called in a state like Uttar Pradesh, the case diary. In your state, in Maharashtra, it might be ki it is known by some other name, Roj Namsar. I'm not familiar ki what is the name given to case diary in your state. The evidence, compilation of evidence in support of the charge sheet or final report compiled by investigating officer is called case diary in Uttar Pradesh. Virtually, it is police report under section 173(2) of the CRPC. The material, the evidence, the documents, the statements recorded and collected by the IO during the course of investigation, it is called case diary here. So I will be referring it as case diary. You can have your own name for this case diary, the police report, or whatever, by whatever name it is called in your state. So before going through the evidence that was recorded by the trial court and that was led by the prosecution before the trial court, let you first go through the story of the police that was developed in the case diary in the form of 161, 164 documents, etc. Then go through the oral and documentary evidence on record. What were the witnesses of facts examined by the prosecution at the trial? What were the private documents that were produced by the prosecution, which were later on exhibited and relied upon by the trial judge for recording his findings? Oral evidence, documentary evidence. In a criminal trial, these are used by the trial courts for recording their judgment, whether it is of conviction or acquittal. So once you are well familiar with the nature and quality of oral evidence, nature and quality of documentary evidence available on the record of the trial court, your task of arguing the criminal appeal would be easier. Simply going through the findings recorded by the trial judge will hardly help you. You will be able to analyze, you will be able to question, assail the findings recorded in the judgment of the trial judge only when you have already marshaled and mastered the oral evidence of the PWs, prosecution witnesses, and also the evidence that was available on record in the form of documents. Section 3 of the Evidence Act defines word evidence. It says it provides for oral and documentary evidence, including electronic records. Earlier, there were only two sorts of evidences, one oral, other documentary. With the passage of IT Act in 2000, Evidence Act Section 3 got amended along with many other sections of the Evidence Act. And then Section 3 included a phrase, electronic records, in the definition of documentary evidence. But Section 3 hardly helps you. If you go through Supreme Court judgments, you will find that there are 4 types of evidences. One is oral, next documentary, Third, electronic evidence. And fourth, tangible objects, sticks, rods, gases, liquids, with splinters of bombs, cartridges, a lot many things which are in tangible form, solid form. They are also evidence at a criminal trial. They are produced before the court. They are collected by the IO during investigation and then produced before the court. Prosecution relies upon it. And if proved, if found credible, they are accepted by the courts for recording convictions. So there are, in fact, 4 types of evidences: oral, documentary, electronic records, tangible objects. Section 3, unfortunately, even today, provides for only 2 types of evidences: oral and documentary evidence, including electronic records. To leave these things for students, we are professional people, so let us talk for our purposes in professional terms. So once you have gone through the oral evidence, gone through the documentary evidence on record of the trial court, your task to argue the criminal appeal becomes easier. Your task to question the findings recorded by the trial judge in his judgment becomes easier. So I am taking you point by point on your role while preparing your argument to argue a criminal appeal. After going through the oral evidence, what should be your duty? What should be your caution, precaution, responsibility to articulate your submissions, arguments? You know, unless you are well familiar with the law of appreciation of evidence, you can hardly appreciate or question or assail the finding reached by the trial judge. Law of evidence is the prime source of evidence. Various provisions, various sections in the Evidence Act provide for the manner in which the evidence is appreciated, when it is discarded, when it is accepted. All these things are there in the Evidence Act, but they are only very basic, elementary level of prescriptions given by legislature. Unless you keep yourself updated with the latest and leading decisions of the Supreme Court, it will be difficult for you to appreciate the evidence on record, to question the findings, to question the conclusion reached by the trial judge. It's not only a duty cast upon the appellate judge, trial judge alone. Your duty is equally important to keep yourself familiar with the laws. As an advocate appearing for the convict appellant before the appellate court, you are supposed to be familiar with the law of evidence, how the evidence is appreciated. And if you have mastered on the subject, then you can very easily question the finding of the lower court, of the trial court, whether it was properly or improperly recorded, whether it was legally or illegally recorded. So I will take you through these duties of yours one by one. You know, if finding by trial court is recorded on oral evidence, on documentary evidence, and if there is any tangible object, electronic record, then of course that is also taken into consideration. How can you question the finding? If you are appearing for the convict appellant before the appellate court, obviously your duty would be to question the finding of conviction recorded by the trial judge. How can you do it? You know, when a witness appears for the prosecution before the court, his examination in chief, his oral evidence in the form of examination in chief is recorded first. Then the witness is handed over to the counsel appearing for defense to cross-examine him. The examination in chief and the cross-examination cover pages and pages. Sometimes a single witness runs into more than 100 pages, 50 pages. Counsel appearing for defense takes days and weeks together in cross-examining a single prosecution witness. Suppose the entire deposition of a particular prosecution witness, including examination in chief and cross-examination, is recorded into 10 pages, only 10 pages, chief and cross. And there are 6 such witnesses, and their depositions run into 10 pages each. So how many pages are covered? 60 pages, only oral evidence. Then there are documents on record running into hundreds of pages. How lengthy a judgment will be recorded by the trial judge? When you go through the deposition of a particular PW, prosecution witness, what should be your duty? What are you searching for in a 10-page deposition of a particular PW? Suppose there is a case of bodily injury. An assault has been done upon the victim. Accused has been charge sheeted. Trial has started. Depositions have been recorded. Now it's a stage of argument, whether before the trial judge or before the appeal court. If the deposition of a single witness is running into 10 pages and that witness is claimed by the prosecution to be an eyewitness, so what should be your search? If that much is found in his deposition, your objective is met. Whether as a liar, whether as a judge, the duty is to locate 3 things in the deposition of an eyewitness. Number 1 is whether the witness was present on the spot at the time of the incident. Number 2, whether he had seen the incident occurring in the manner as stated by the prosecution in its papers and as described in the charges framed against the accused. And number 3, judging the credibility of the witness. I'm again repeating it. Presence of the witness on the spot at the time of occurrence. Number 2, whether the witness had seen the incident. Number 3, whether the witness is credible. It is the duty of the court to record finding all these 3. And while arguing a criminal appeal or even before the trial judge, it's your duty also. In a deposition of a witness, you make up your mind out of his deposition whether he was present on the scene of the offense, whether he had seen the incident. How can a blind man, though he might be present on the scene, could have seen the incident? Or the incident had occurred in darkness of night. Even if witnesses were there at 100 meters away or some other distance, how could they see it unless there was some source of light? The presence of witness on the spot, incident having been seen by the witness, these are 2 cardinal methods, tests, which are applied to study, to read the deposition of a witness. A reader of the deposition locates these 2 things first. Out of many pages of deposition of the witness, where are these things? Where is that line? Where is that piece of statement of the witness where he claims that he was present on this spot and had seen the incident? If a witness appears for prosecution and states to the court, whether in chief or cross, though I was present on the spot, but I could not see the assailants. I could not see the weapon, the manner in which the occurrence had taken place, because it was quite dark. The witness has hardly supported the prosecution case. It doesn't help the prosecution. The presence on this spot, having seen the incident, these are two basic things which should be located in the deposition of the prosecution witness. As lawyer, when you are arguing the criminal appeal, you should point out to the appellate judge, the honorable court, look here. These are the lines appearing in the deposition of the witness recorded before the lower court, where he has claimed that he was present on the spot but could not have seen the incident because of darkness. And if the trial judge has still recorded a finding of conviction based only upon the deposition of this witness, then that finding is wrong. That cannot stand. It has to be set aside by the appellate court. Because the test is, what test must be fulfilled? Presence of the witness on the spot. He must have seen the incident. And when a positive finding is recorded on these 2 points, then the third one is whether the witness was truthful. These 2 things can be told to the court even by a lawyer, even by a witness who is untruthful, who is telling lies to the court. So this third test is the most important test, how the credibility of a witness is judged, how a witness is declared to be a true witness, a credible witness, or a witness telling only lies to the court. So judging credibility of the witness is the most important task of the court, and it requires a lot of knowledge and skill, even on the part of the arguing advocate, to suggest to the court whether the witness was truthful or untruthful. So now I will take you through all those methods which are applied to test the credibility of a witness. There is a long article of mine available on this point on my website, lawhelpline.in. It runs into more than 100 pages with all the latest, updated, leading Supreme Court judgments. Smaller points which are raised, which are argued in courts, they are dealt with in this article with the support of the Supreme Court cases, rulings. So when there is an eyewitness in a case, and he has claimed in his deposition before the court that he was present on the spot, he had seen the incident, he had seen the assailants assaulting the victim, the injured. Then third point we will be dealing from here is whether the witness is reliable, credible, or he has told lies. So what methods are applied? You know, contradictions, embellishments, exaggerations. These are bound to appear in the deposition of a witness. There can be no witness in this world in whose deposition one or more of these things do not appear in his deposition. A witness is bound to err on many counts, but it is not necessarily bad for the witness. fatal for the prosecution. Contradictions are treated to be natural. When after lapse of time, a witness appears before the court and deposes in favor of some particular incident, it's humanly not possible to precisely narrate everything in the manner it had occurred at the time of occurrence. So the tests which are applied to judge the credibility of the witness are: number one, contradictions. Every day you argue, this is major contradiction, this is minor contradiction. The prosecution will say all the contradictions which had appeared in the deposition of the witness were only minor, natural. You as defense counsel, as counsel engaged by the convict appellant, will argue, these were major contradictions and had gone to the root of the credibility of the witness. So you take your position, public prosecutor takes his position, then matter is left for the court to decide. Here I am discussing your role. How should you view a contradiction appearing in the deposition of a witness? What contradictions are said to be major and what are minor? What are the tests to see, to apply, to judge a contradiction is minor or major? If it is minor, natural, it will not be given any weightage, any importance by the court. Witness will be declared credible, reliable, dependable. And if the contradictions are major, which shake the credibility of the witness, then contradiction will be declared by the court as major, fatal to the case of the prosecution. But the test is, I had earlier pointed out three things to you to judge the credibility of a witness. One, the witness must state that he was present on the spot at the time of occurrence. The witness must state that he had seen the incident. Now, credibility question. If the witness states that he had reached the spot after the assailants had gone from there, and I could not see the assailants, the accused persons. So though he claims to be present on the spot, though he claims that he had reached the spot after hearing the noise, but he is not telling to the court that he had seen the assailants assaulting the victim. So his reaching the spot or not reaching the spot hardly helps the prosecution. If in examination in chief, the witness says that he had reached the spot when the incident was occurring, and during cross-examination he says, yes, I had reached the spot, but only after the assailants had gone. In chief he says that I was present. In cross he says that though I was present, but by the time I reached, assailants were not there. They had gone. There is a contradictory statement. There is contradiction between these two statements of this witness, one in chief, other in cross. Whether this contradictory statement that has appeared in the cross-examination that he had not seen the assailants because by the time he reached, they had already gone, it is not a minor contradiction. It is very, very major contradiction. His claim in the chief that he was present when the incident was occurring stands completely contradicted, falsified by this witness himself. So when a witness makes a statement in his deposition contradicting this first requirement, presence of the witness on spot, then contradiction is not minor, it's a major. Similarly, if he says, I was already present on the spot, or I had reached the spot soon after the incident started, but because of darkness, I could not see the assailants, the victim, and all those who were standing around the place of occurrence, then this statement is also not a minor contradiction. It's a major contradiction. To sum up, let me tell you, if a witness contradicts its previous statement on these 2 points, one, presence on the spot, other, having seen the incident, then contradiction is not minor, it is major. Because he is shaking the very foundation of the prosecution case. He is shaking the very foundation of his credibility as an eyewitness. A witness who was not present on the spot or who had reached the spot late when the assailants had gone, was it possible for him to have seen the assailants, have seen the incident occurring in the manner as stated by prosecution in its case? Obviously, answer is no. All other contradictions are always treated as minor. Suppose that some 5 years back, on February 5, 2017, an incident had occurred. There was an eyewitness. After 5 years, he has appeared before the court to depose in support of the prosecution story. He is not able to tell the correct date, February 5th. He is telling, there was a question from defense side. Mr. Witness, tell what was the date when this incident had taken place, what was the month, what was the time. And the witness is telling wrong date, wrong timing, wrong month, or even wrong year, wrong weather. Everything is okay. All these contradictions are only minor. They are not to be treated as major contradiction, because it is quite natural, obvious for a witness attending the court after long lapse of time. It's a human weakness. Memory fades with the passage of time. And people err in describing anything, any event after lapse of time. So is the case with the witness. He is erring. He is not able to precisely narrate, correctly state the date, time, whether, month or year. These contradictions are not major. They have to be treated as minor and will not be given any weightage. If there are no discrepancies in the deposition of this witness, he will be treated to be credible. A conviction would be the outcome of the case. Why? Why these contradictions will not be given weight? Because such contradictions are natural. Witness has not erred in telling to the court regarding his presence on the spot at the time of occurrence. Witness has not erred in telling to the court regarding having seen the incident, regarding the assailants. The two primary things which must be proved by prosecution at a criminal trial is presence of the witness, having seen the incident. If these two things are proved, there are no contradictions on the part of the witness on these two things, presence and having seen, then all other contradictions are always treated minor. So as an advocate arguing a criminal appeal before the appellate court, your duty should be to see in the deposition of the witness whether he has contradicted his presence on the spot, where he has made any statement in his chief or cross, which makes his claim doubtful that he had seen the occurrence, he had seen the assailants. If you are able to show to the appellate court any one of these two, then the case of the prosecution is gone. It's a fatal for prosecution. If still a conviction has been recorded by the trial court, the finding would be set aside by the appellate court. I would request you to keep in your mind the basic tests which are applied in judging the credibility of a witness. I'm again repeating, if the witness is said to be an eyewitness, you must see out of his deposition whether he was present on the spot, whether he had seen the incident. If these two things have gone positively in favor of prosecution, then you are helpless. You cannot earn an acquittal. But if any of these two has been contradicted by the witness at trial in his deposition, then appeal will be allowed. Finding of conviction recorded by the trial court would be set aside, unless there are other witnesses, any other witness to support the prosecution. So this was the first prime duty which a criminal lawyer arguing a criminal appeal owes to the court. Your duty is to assist to the court according to law. Your task becomes easier when you know the law, when you know your role, when you know the function of the court, when you know the requirement of law. The task of the judge also becomes easier when he knows his function well, when he knows the laws. Otherwise, wasting time in reading depositions of witnesses running into hundreds and hundreds of pages, and then more than 200, 300 submissions made by the public prosecutor and the counsel appearing for defense. These are not meant for court. It's not every argument put forth by you or the public prosecutor that will find place in the judgment. There are some specific requirements of a judgment. If it is a judgment of conviction, it requires specifics. If it's an acquittal, equally it requires some specifics in support of innocence of the accused. If it is judgment of conviction, then in support of guilt of the accused. The entire exercise should be focused by you, by the judge, by the public prosecutor on these things. Wherefrom you can find the laws on it. You go to my website, lawhelpline.in, go through the article captioned Appreciation of Evidence in Criminal Trials and Appeals. Because CRPC gives only procedural prescriptions. Substantive part, the guiding part for recording guilt or innocence of the accused comes from Evidence Act, from the laws of the Supreme Court on Evidence Act. And let me point you out one article of the Constitution of India, Article 141 of the Constitution. This article says, law propounded by the Supreme Court of India shall be binding upon all courts. Once a legislative provision of an act is interpreted by Supreme Court in a particular manner, then that interpreted law is binding, not the legislative words and phrases, languages given in the act. If after reading the legislative language of the act and after going through the judgment of the Supreme Court interpreting that section, if you find some difference, contradiction, then you have no choice except to go by the interpretation of the Supreme Court. Because Article 141 of the Constitution mandates The interpreted law of the Supreme Court is the binding and final ultimate law, not the legislative provision enacted by the legislature. Because Supreme Court is the final arbiter on the issue of interpretation of laws, even of the Constitution of India. In a case in 1994, Supreme Court Advocates on Record versus Union of India. That was a 7-judge bench judgment of the Supreme Court, Constitution bench judgment. Supreme Court ruled the Constitution of India is not that what was drafted by the Constituent Assembly. Constitution of India is what we judges say it is. And if you go by more than 800, 1,000 judgments of the Supreme Court during all these decades on the Constitution, you will see that a parallel Constitution has been written by the Supreme Court out of these decades. And the real Constitution comes from the Supreme Court judgment. Critics say the Supreme Court has no role to supplement or supplant phrases, words, provisions in the Constitution of India. Let them say. The same very Constitution in the form of Article 141 says that interpretative power is vested only in the Supreme Court. The law they declare will be binding. The power of judicial review, the power of interpretation is vested in courts, Court of Records, High Court and Supreme Court. So I am just pointing out to you this Article 141 to remind you that your duty is to keep yourself familiar with the leading judgments of the Supreme Court, propounding law, laying down laws on the evidence side. Only then, brothers and sisters, you will be able to correctly assail the findings recorded by the trial judge in his trial judgment. I was just discussing the contradictions. I would welcome if you put some questions on the issues which
Yes, sir.
I
There
so
are
far.
some questions.
Right.
There are some questions in the chat box of YouTube. Sir, if you permit, shall I ask you?
Hi. You simply ask me and I will reply.
Yes, sir. The one attendee is asking that can we introduce any new point of evidence in criminal appeal? If yes, what is the provision and what is the procedure of introducing the same?
Section 391 CRPC. Section 391 CRPC provides for production of additional evidence at the appellate stage. But there are many riders, preconditions. Otherwise, an appeal has to be decided on the basis of evidence that was led by the parties before the trial court. This section 391 CRPC is an exception to this general rule. The Supreme Court decisions, leading Supreme Court decisions on section 391 are mentioned by me in the article Appreciation of Evidence in Criminal Trials and Appeals, and also under the article Law of Criminal Appeals. This is available on my website, and ask the participant making the query to go through this article, Criminal Appeals. There is a major caption in red ink, criminal laws, and at item number 15, there is appeal within brackets criminal, appeal criminal. If you open this and search for 391, then a number of rulings of the Supreme Court will appear in front of you. The Supreme Court rulings say at appellate stage, the appellate court does have power to admit a new evidence led by the party. But ordinarily, appellate courts should not encourage, should not allow production of any additional piece of evidence at appellate stage. Unless the party convinces, satisfies the appellate court that despite all due efforts, despite all due diligence, the party had not been able to produce this evidence before the trial court, or the evidence which the party has sought to produce before the appellate court now was not in the knowledge of the party when the trial was going on before lower court. So if these reasons are there, a valid reason is there, a convincing reason is there, appellate court does have the power under 391 CRPC to permit production of appellate or additional evidence at appellate stage. Otherwise, court would not allow a party to fill up its lacuna at appellate stage. If the production of additional evidence is inspired by mala fide motives to linger the appeal, or the evidence that is sought to be produced at appellate stage is not relevant, it does not reflect upon the outcome of the case, is not relevant, is not helpful to reach a just decision, court would reject the request. But if the party is able to satisfy the appellate court that the evidence is necessary, is material, it reflects, it helps the court to reach a just decision, and the party had not been able to produce it because it was not in the knowledge of the party during trial, or despite efforts, its a copy could not be procured, evidence could not be procured by the time the trial was concluded by the trial court. Then if such conditions are satisfied, of course, appellate court has power. It can allow. Provision is there. 391. Host of Supreme Court judgments rulings are there in this article, which I have prepared for judges, for magistrates, and of course for lawyers. So ask the participant putting the query to consult this subject of mine, criminal appeal criminals, on my website, lawhelpline.in.
Sure, sir. The next question is actually, it is being asked by a judiciary aspirant. He is asking for books which we can be used for preparing the district judge examination.
He wants to appear in higher judicial services from bar.
Yes, sir, for district judge.
I extend my good wishes. He must adorn a position in judiciary, and he must make sincere efforts. It's within his reach, within his caliber. If he sincerely devotes him, he can, even in first attempt, get a position in higher judiciary. So he is asking me which book he should read.
Yes, sir.
On evidence. On
sorry,
Evidence
sir.
Act.
No, sir. He is asking for criminal law.
Criminal law is a very vast subject. CRPC, evidence, IPC. Being myself an author, it's very difficult for me to suggest a book of any author for someone. But still, if he wants to know it from me, there are many books, many commentaries, good commentaries. And of course, there are some outdated and bad commentaries too. In your state, Maharashtra, I would suggest him to consult some newly recruited additional district and sessions judge. If he knows someone in your state. He will be in a better position to suggest you which author in Maharashtra is most celebrated on CRPC, on IPC, on Evidence Act. Pan India, there is Sarkar's committee, there is Ratan Lal Dheeraj Lal's committee, and of course, in his North Indian states, there are many other local authors. So, suggest him to which committee he likes, which committee people in your state suggest him. I am just telling you some names of some famous authors, Sarkar and Ratan Lal Dheeraj Lal, the oldest ones. So they are there.
Okay, sir.
Other
Sir,
question?
the next question is like it is not related to criminal appeals, but it is related to warrant cases. So if you permit, can I ask you?
Yes. Why not?
Sir, his question is, how is pre-charge evidence conducted in warrant cases?
Pre-charge means in your state? In complaint cases?
In warrant cases.
In warrant cases, you know कि warrant cases start from two sources. One is on a charge sheet, say the police report submitted by investigating officer under section 173(2) of the CRPC. When a charge sheet is submitted after investigation, charge sheet word is not there under section 173(2) or anywhere in CRPC. There is police report, word police report. A charge sheet or police report is submitted after investigation by the IO, investigating officer, under section 173 subsection 2. That is called police report in legislative language. And in ordinary parlance, it is called charge sheet or final report. Final report is also police report. Charge sheet is also police report. Police report means two things. Either it is charge sheet or it is final report. Both are submitted under section 173(2) of the CRPC. If it is a case that had started on charge sheet, then there is no complaint. There is no pre-stage, pre-trial stage evidence. At pre-trial stage, there are statements of witnesses recorded by the investigating officer either under section 161 of the CRPC or by my state under section 164 of the CRPC. If it is a complaint case, then you know before the trial commences in a warrant case, the process of 200, 202, 203, 204 CRPC is exhausted. That means a formal written complaint is filed before the magistrate. A statement of the complainant is recorded under 200 CRPC. And if he produces any witness on same very day, his statement is also recorded under 200. And if the case is deferred, urgent, then under 202 CRPC, the statement of his witnesses are recorded. The documents which the complainant wants, they are taken on record under these two sections, 200 and 202. Then either the complaint would be dismissed under 203 or summoning order will be passed under 204 of the CRPC. So at pre-trial stage, these statements are there on record if it is a complaint case. But these statements are not covered within the definition of word evidence as defined under section 3. A statement of a witness under 161, 164 CRPC is also not covered within the expression evidence under section 3 of the Evidence Act. Section 3 Evidence Act defines word evidence. It is called substantive evidence, admissible evidence. A finding can be recorded by court only on the basis of substantive evidence led by parties under Section 3 of the Evidence Act. A statement of a witness recorded in a complaint case under Section 200, 202 is not evidence. It is a statement. A statement of a witness recorded by investigating officer under 161 CRPC or by a magistrate under Section 164 is a statement, not evidence. Evidence is that which a witness deposes before the court. Evidence is that which is produced before the court either by the investigating agency or by the prosecution, public prosecutor, or by the defense. And if it is a private document, when it is proved, its execution is proved and it is exhibited, only then it becomes evidence. The finding judgments are recorded and passed on the basis of evidence that is led before the court. All other statements, whether under 200, 202 CRPC or under 161, 164, they are not evidences. They are former statements of witnesses. They are either used for contradicting the witness under 145 of the Evidence Act or under Section 157 for purposes of corroborating the previous statement or the statement before the court of the witness. Suppose that witness Ram Prasad appears in support of the prosecution as PW1 and supports in his deposition the prosecution story. This witness PW1 Ram Prasad had also made his statement to the investigating officer under 161 CRPC during the course of investigation. So his former statement recorded by investigating agency under 161 will be used for purposes of either contradicting him or corroborating him. If his previous statement under 161 supports his statement made to the court during trial, then it is called corroboration. He is finding corroboration. His deposition before the court is finding corroboration under Section 157 Evidence Act. And if he has made two contrary statements on one and the same very fact, one under Section 161, other before the court, then there is contradiction. Then it will be used under Section 145 of the Evidence Act. Any statement recorded of a witness at pre-trial stage is used for purposes of contradiction or corroboration in accordance with the provisions of Section 145 or 157 of the Evidence Act. This is the scheme of CRPC. This is the scheme of Evidence Act. And this is the law meant for trial of cases. This is the law for deciding the criminal appeals.
Okay,
Yes.
sir. The next question is, at what stage are all the documents that the prosecution is relying upon are provided to the accused?
207 CRPC. Providing copies of prosecution papers to the accused. Your question is this one?
Sir, he is asking at what stage are all the documents, that is, I suppose he is saying that FIR, charge sheet and all the statements which are recorded in the
Got
charge
the
sheet.
point. Got the point.
Yes.
There is a section in CRPC 207 CRPC. You know, when investigation is over, what is done by the investigating officer? A police report is submitted to the court under Section 173 to CRPC, say charge sheet or final report. And FIR will end either into a charge sheet or into a final report under Section 173(2) of the CRPC. Then what is next stage? Suppose today a charge sheet is submitted by the IO. IO means investigating officer. Suppose a charge sheet is submitted today to the court by the IO. What will be step number 1 of the magistrate before whom the charge sheet is filed? He will take or refuse cognizance. Section 190 CRPC. There are three subsections. 191, 190, subsection 1, subsection 2, subsection 3. 190 empowers the magistrate to take cognizance of the offences. This is first step by magistrate, or if a charge sheet filed before the session judge or additional session judge, the first step for him on receiving a charge sheet, first step to be taken by court is to take cognizance of the offense and issue process to the accused. Summon, bailable warrant, non-bailable warrant. Normally, summons are issued. Taking cognizance and issuing process to the accused to appear before the court to face trial. When the accused appears on the date fixed by court, then first, the second step would be to provide the accused copies of all the documents, the charge sheet, the statements of witnesses recorded under 161, 164, the documents collected. If there are electronic evidences like CD, like pen drive, like this, that, copies of these electronic evidences, everything will be provided to the accused under section 207 CRPC. Suppose court failed to provide copies of all these documents which were collected, which were submitted by the IO during or after investigation and submission of charge sheet. A charge sheet together with statements of witnesses under 161, 164, together with documents is submitted to the court. Court is duty bound to provide copies of all these to the accused under section 207, but the court has failed to provide. What would be the result in law? If the accused knows the contents of these documents, if it does not demand copies, then he cannot say, no, I was prejudiced because copies were not provided. The cardinal test is whether in the absence of copies to the accused, any prejudice, injustice was caused to him. If the answer is yes, then it's fatal for the trial for not providing copies to the accused. But if the accused fails to show that any prejudice was caused to him, then it's not fatal. Suppose that charges were framed, the next step would be framing or discharging the accused, framing charge or discharging the accused. Sections 238, 237, 239, 239 in a warrant trial, these are the sections there. Still copies can be provided to the accused. The basic test is whether any injustice or prejudice is caused to the accused for want of copies. If answer is yes, then court is duty bound to provide copies even at later stages of proceedings. If at the initial stage of section 207 CRPC, it could not be provided, the court should provide it to the accused at later stages. Suppose even at later stages, copies have not been provided to the accused, at the time of final argument in the case, at the time of judgment, or in the appeal after conviction, accused is taking this plea that he had not been given the copies. So what was he doing all these years and months? He should have raised these objections earlier. It means that during the course of trial, he was not prejudiced at all, because had he been prejudiced for want of copies, he would have raised his objections. at the earliest available opportunity. But since no prejudice was caused, injustice was caused, he was already familiar with the contents of the papers, and he had got sufficient opportunity to defend himself during trial. Therefore, at later stages of proceedings, he would not be heard. That copies were not provided. So this is the ordinal test. There are Supreme Court rulings where from you will get. Again, go to my website lawhelpline.in. There is a file, a subject, miscellaneous judicial problems of courts. This is the name of the file, miscellaneous judicial problems. It is some more than 100-page article. There are many Supreme Court rulings recorded on this point. Again, I am reminding the questioner. The basic test is prejudice, test of prejudice, test of injustice. If for want of copies, injustice is caused, of course, it will be complied with. But such pleas should be taken by the accused at the earliest available opportunity. A charge is being framed today. Accused is present, his counsel is present. Why he is silent? Why he is not saying today? The Honorable Court, look here, I have not received the copies of police papers. Kindly direct the office, your court staff to provide me a copy, or the prosecution to provide me copies first, only then here and frame the charge. If he raises a plea like that, he is okay. He can question it, he can say it. But he is silent at that time. Trial concluded, he was convicted. In appeal, he is saying, I had not received the copy. It's for you. What prevented you from raising your plea of prejudice of not being provided with the copies earlier? I think I have sufficiently explained to you, and the questioner must have understood it in its right perspective. Okay.
Yes, sir. The last question is, can you guide on the art of writing criminal judgment for the examination of district judge?
Whether it is district judge, whether it is magistrate or anybody else.
Sir, district judge.
Whoever wants to know the art of writing judgment, art of passing judgments and orders, judicial orders, he must go through an article of mine available on website. If you allow me to speak in my language, हर मर्ज की दवा उसी साइट पर है. समझ में आ रही कि नहीं? There is medicine for all the diseases on that site, lawhelpline.in. The name of the file is How to Record Judgments and Orders. You people are taking me to variety of subjects and I'm enjoying it. So I'm just explaining how a judgment and order should be passed. In brief, a court needs three things to pass a judgment, whether it is a civil case or a criminal case. Number one is fact. Number two, evidence. Number three, law. Three things. I'm again repeating. Fact, evidence, law. In legal parlance, they are called marshalling of facts, appreciation of evidence, application of relevant law. With the help of marshalling of fact, appreciation of evidence, applying correct law, findings are derived, findings are recorded. And when the findings are recorded, then the operative part of the judgment, the conclusion is recorded. Meaning thereby whether the relief is being granted or refused, if it is a civil case, and if it is a criminal case, whether the accused is being declared innocent, meaning thereby he is acquitted or convicted. And then how judgment is passed. First, facts are stated. Then if charges are framed, charges are referred. Then the evidence led by prosecution and defense is quoted. It doesn't mean the entire evidence will be reproduced in the judgment. It will suffice if it is stated that the prosecution examined 8 witnesses, PW1 Ram Prasad, PW5 Ganesh Mohan, PW8 Muhammad Altaf, and produced documentary evidences enumerated below. 1, 2, 3, 4, 5, 10 documents will be referred here. In brief, in a paragraph, in 2 lines. Then defense witnesses, DW1 so and so, 2 so and so, document so and so will be quoted. Then arguments of counsel for both the parties will be heard. Then findings will be recorded, evidence would be appreciated and finding would be recorded. And last part would be the operative part, granting or refusing relief in a civil case, or in criminal case, convicting or acquitting the accused. These are the steps. What are different steps in a criminal trial? Let you people know. Which is the stage in a criminal case? Which is the starting point of trial in a criminal case? Will somebody tell from among the audience? Participants?
Sir, lodging of FIR
is the starting point of trial. Then what is prosecution? What is investigation? What is investigation then? Investigation is one thing, trial is other thing. A trial in a criminal case starts with the framing of charges. Let you keep it in your mind. Trial in a criminal case starts with the framing of charges. If today charges are framed, trial is started today. Registration of FIR, arresting accused, remanding accused, granting or refusing bail to accused, taking cognizance of the offense on charge sheet, providing copies to the accused under section 207 CRPC. All these stages are not covered within trial. They are pre-trial stages. Proceedings taking place at pre-trial stage. Understood? With the framing of charges, trial commences. Similarly, in a civil case, with the framing of issues, trial commences. When issues are framed under Order 14 of the Evidence Act, under Order 14 of the Code of Civil Procedure, then trial is said to have commenced. With the framing of issues, with the framing of charges, trial commences in civil and criminal cases respectively. All right.
Yes, sir.
Next.
Sir, there are no questions further.
Why?
I thank.
No. Don't thank. Why are not there more and more questions? Let there
yes,
be
if anyone
more
has
questions.
any question, he can unmute himself and ask. But in chat box, sir, there are no questions.
In chat box, there are no questions. But I know, even those judges who have put in their services for 20 years, 30 years, they put questions in classes to me. So for novice people, why there are no questions? Why they are reluctant in putting questions? You take me to any subject which are dealt with by the courts. I don't mind कि you have today asked me to deliver my talk on criminal appeal, and I just covered some 20% of the subject. It's a vast subject. Since you people wanted to take me to different subjects, and I don't mind that, I'm enjoying. And I will entertain, I will rather love to entertain more and more questions. Ask people to mute or unmute and then ask their question directly.
Yes, the participants are requested to unmute themselves. They can unmute and ask questions. Sir, I think there is no question for now.
So,
They
our
don't
time
have
is
any
over.
question for now.
We can continue, or our time is over now?
Sir, the time is also over and they also don't have any question because it's 7:30 now.
7:30 now, right. So then, all right, let you conclude.
Yes, sir. I express my deep sense of gratitude to Advocate S.S. Upadhyay, sir, for taking his time out and accepting our invitation and addressing the queries as well. I also thank Advocate Jeevan Pedgaonkar, because of whom it is possible to listen to sir. I also thank all the attendees who have for evincing interest in today's session. Thank you, one and all.